Now, the next question that you have to face in the law of contract is the question of classification. It turns out that what happens is, as a matter of course, is that people, when they enter into contract, usually think about some fraction of the relevant issues, but they don't necessarily think about all the particular details in question. These kinds of vitiating conditions are something that run through the entire body of contract law and are not necessarily tied up to this, that, or the other form of contract. And a lot of what the law of contract does is to try to set up a series of terms which you may be free to vary, but typically won't even think about when you're worried about a particular transaction. So let me just give an extremely simple example. What happens is I go into the store and I say, I'd like to get a pound of potatoes. And so what we do is we imply a series of concurrent conditions in these transactions. And what the conditions say is, I do not have to pay you for the potatoes until you tender them to me, and you don't have to tender the potatoes until the cash is ready on the table. And the theory is each party can treat its promise as security for the others so that they go forward simultaneously or not at all. And this then becomes part of the implied law of conditions. And there's a kind of deep rationale, as applicable in Roman times as today, as to how these conditions are inferred. Now, how is the rubric under Roman law for doing this? And at this particular point, the phrase that often comes into use is it's good faith. And what we're saying about good faith is these are the kinds of things that you have to do in various kinds of arrangements in order to make them robust. So that if you, in effect, act in bad faith, then it turns out that I don't have to do this at all. And so what the Roman law does is it develops bona fide contracts, and those are typically sale. They're contracts of hire, contracts of partnership, and contracts of agency, which we'll talk about. And then there are other promises, like loans and so forth, which tend to be stricta juris. And then there are a third class of contracts known as real contracts, in which it turns out that what you do is you have various kinds of gratuitous arrangements, and you have to sort these things out. So what the Romans do is they develop a very elaborate system. And the genius of what they've done is they seem to get the right categories for the various kinds of arrangements. And they seem, as a first approximation, to get the right substantive rules as default terms for each of these kinds of arrangements. And for the most part, what they do is they allow, but only occasionally, you to vary these standard terms to do something else.